Hello, this is Dane Ciolino, and welcome to our MPRE review videos. Over the course of the next several hours, I am going to talk to you about getting ready to take the Multi-State Professional Responsibility examination. What I'm going to do principally in these lectures is to talk about the content, the rules, the standards that you need to know in order to succeed on the MPRE, the rules governing conflicts, confidentiality, the different roles of lawyers, those sorts of topics. But keep in mind that that's not all that needs to be done in order to prepare yourself for the MPRE. It's critically important that you spend some time after you've gone through the doctrine actually working through some practice MPRE questions. Only by seeing how the testers ask questions about these topics can you get yourself familiar with the MPRE format. And also it tends to be somewhat tricky for some students the first time they try it. So you don't want the first time you're experiencing MPRE questions to be when you're actually taking the test. So this is my recommendation to you to get yourself ready for this test. You ought to, of course, go through all of these mind maps. You ought to preferably make your own set of mind maps or mini outlines, because you're going to be a lot better at understanding and regurgitating this information if you have actually processed it yourself in your own hand by making your own outline or your own mind map. So you need to go through, process all of this information, make sure that you understand it. Anything that you don't understand, you should go to a treatise or a study aid to get some more background on. And then you need to spend some time working through practice questions. Now, they've got very good practice questions that are available for download on the NCBE site. You have to pay a relatively modest fee, $35 or so, for the practice tests, but well worth it. After you do that, just make sure you get a good night's sleep before the exam on Saturday, and then show up with your sharpened pencils ready to do your best. So what are the topics that we're going to address? We'll start out here by talking about regulating lawyers, the sources of lawyer regulations. We'll talk about the bar admissions process, discipline. Then we'll go to the basics of the lawyer-client relationship. And of course, this deals with competence and diligence, confidentiality, and Rule 1.6 in the attorney-client privilege, and then the basic obligation of loyalty, which is the obligation to avoid conflicts of interest, both concurrent conflicts, former client conflicts, and then we'll talk about some miscellaneous conflicts issues. We'll then turn to the business of law and deal with some issues related to law firms, supervisory lawyers, subordinate lawyers, advertising and solicitation. And then after that, we'll talk about the different obligations attendant to different lawyer roles. For example, the obligations of a lawyer as a counselor, as an advocate, and in dealing with third persons. Finally, we'll talk about lawyers as public servants. And then finally, in the last series of lectures, we'll deal with judicial ethics. And though it's a relatively small part of the MPRE, it's an important part of the MPRE, and we'll deal with the 3 or 4, not that many, 2 or 3 questions that you might see on the MPRE related to judicial ethics. So let's get started. Let's now talk about regulating lawyers. Who regulates lawyers? What branches of government are involved in regulation? We'll talk a little bit about the disciplinary process, and this is really just kind of the setup and the basis for responsibility if lawyers violate the rules that we are going to talk about in more detail. Okay, let's talk now about regulating lawyers, and the first topic that I want to take up are the sources of regulation. Now, by and large, lawyers are regulated at the state level. State of Louisiana, the state of Mississippi regulates lawyers. And within those states, it's generally the courts that have that inherent authority to regulate lawyers. And if the legislature gets involved in trying to regulate lawyers, sometimes courts are going to find that the legislature has overstepped its constitutional authority and violated the separation of powers. So courts within states have the authority to regulate lawyers, and those courts promulgate the rules of professional conduct. Now, most are based on the ABA model rules, although not all. I would think all but 2 or 3 states follow the ABA model rules. For purposes of the multi-state professional responsibility exam, just assume that the ABA model rules are essentially gospel. Now, as far as federal court regulation, federal courts do regulate the practice of the lawyers who appear before them, but other than that, they are applying the state standards in the states in which they sit, and that's something that bothers federal prosecutors sometimes, but that is the law. Now let's talk a little bit about bar admissions, how it is you can become able to practice law. Well, of course, it all starts off with an application, and that application is one that has got to be filled out completely accurately, no false statements, and you have an obligation to disclose truthfully, if you are a lawyer and asked about a bar application, to disclose the information necessary for the authorities to make decisions about whether to admit a candidate. So once the application is filled out, the next thing is the character and fitness review. The applicant bears the burden of proof by clear and convincing evidence that she is fit to practice. There is, of course, a right to due process. If you're denied admission, you typically have the right to a hearing at which you can demonstrate your character and fitness. Most conduct is relevant in this regard. Criminal conduct, even if you weren't convicted, that conduct can be the basis for denying you admission. Including the refusal to take an oath can perhaps be relevant. However, not nonviolent political activity. They can't hold your political views against you. What about citizenship? Do you have to be a citizen of the state? No, the state, because of the Equal Protection Clause, cannot require citizenship as a prerequisite to bar admission. And under the Privileges and Immunities Clause, they can't require in-state residency. That being said, they might be able to require an in-state office, but they can't require residency. Next issue, discipline. All right, assuming that you have been admitted to practice, what happens if you engage in misconduct? Well, misconduct is defined in Rule 8.4 as, of course, any violation or attempted violation of the rules of professional conduct. And that's essentially the enabling language that allows courts to impose discipline for violations of the rules of professional conduct. But the rest of 8.4 goes on to deal with circumstances that can lead to discipline even though no particular rule has been violated. Take 8.4b, that deals with criminal acts that reflect on the honesty, trustworthiness, or fitness as a lawyer. For example, there have been lawyers who have been disbarred for example, putting a cat in a microwave oven, for example, DWI offenses, drug offenses. Even though they don't have any direct bearing on the lawyer's ability to practice law, they still are enough to result in discipline. Another catch-all is any act of dishonesty, fraud, or misrepresentation. If you, for example, steal from the Student Bar Association or your homeowners association, that can lead to discipline. Conduct prejudicial to the administration of justice. This is very broad. I've seen this with lawyers fighting in court, for example. Anything that causes the judicial system to grind to a halt or impairs the fact-finding function of courts. Implying the ability to improperly influence an official. If you say, oh yeah, I know that judge, that would be a problem. Knowingly assisting a judge in a violation of a judicial canon. And then most recently, as of 2016, the ABA now has included harassment and discrimination as a disciplinary offense if it relates to or is on the basis of race, sex, religion, ethnicity, age, sexual orientation, gender identity, disability, socioeconomic status, in conduct related to the practice of law, very broad, legitimate advocacy is accepted. And keep in mind that the comments to this new as of 2016, this new rule define harassment very broadly to include all conduct and all words, verbal or nonverbal conduct and communication that is demeaning. Doesn't even have to be harmful. Also keep in mind that the comments allow certain types of discrimination, namely discrimination for purposes of diversity and inclusion, and discrimination for purposes of serving the needs of the low income. The reporting obligation. Now, lawyers, of course, have an obligation to report misconduct of other lawyers. If they know about it, that's an actual knowledge standard, and it's conduct that raises a substantial question about the lawyer's honesty, trustworthiness, or fitness. If he's just run a stop sign and violated the law, which of course would violate 8.4b, however, it doesn't really reflect on his honesty, trustworthiness, and fitness, and doesn't raise a substantial question in that regard. Therefore, there would be no reporting obligation. You also can't report if the information is confidential under Rule 1.6. And that would be, for example, if you were representing a lawyer and he told you about something he did, no obligation to report that. How does the disciplinary process work? Well, usually it starts with screening, and after it's screened, then and it goes to formal charges, then there's a hearing. Lawyers have a right to due process at that hearing. Lawyers can assert the Fifth Amendment right to remain silent, and no discipline can be based solely on that invocation. The state bears the burden of proving by clear and convincing evidence, usually, that the respondent has committed professional misconduct. What sanctions are available? Public or private reprimands, suspension, and of course disbarment is the most serious of all sanctions. What law applies? This is a relatively new addition to the rules. Rule 8.5 says that if the misconduct happened in a tribunal, then you apply the rules of that tribunal. If not, you apply the rules of the jurisdiction where the conduct had its predominant effect. All right, next issue, UPL MJP. Now, UPL, of course, means unauthorized practice of law, and MJP means the multi-jurisdictional practice of law. And MJP really is when it's allowed for a lawyer to go in another jurisdiction, even though she's not licensed to practice there. And UPL is when a lawyer gets herself into trouble because she's gone into a jurisdiction and practiced law, or helped a lawyer in her in-state jurisdiction practice law. All right, let's start out by talking about UPL by a lawyer. This is, you would think, how can a lawyer be engaged in the unauthorized practice of law? Because after all, the lawyer has a license. But lawyers can be engaged in an unauthorized practice of law. How? Well, one, by holding out that the lawyer is admitted in some other jurisdiction when he's not. Systematic or continuous presence in another jurisdiction when the lawyer is not licensed there. Improper delegation to staff, like, for example, allowing paralegals to settle cases. Now, of course, it's okay if the lawyer supervises and takes responsibility for the non-lawyer's work, but otherwise it could be improper delegation to staff. Also, improper affiliation with a suspended or disbarred lawyer, who are generally treated just like paralegals or non-lawyer staff. Now, that's UPL by a lawyer. When can a lawyer temporarily engage in the multi-jurisdictional practice of law? Well, first of all, a lawyer can do this if he is actually, if he is admitted in another U.S. or a foreign jurisdiction and not suspended or disbarred, and one of these things also happens in the new jurisdiction. The lawyer associates with active local counsel, or the lawyer is sworn in pro hoc vice, or the lawyer is engaged in ADR arising out of his home state practice, or the conduct in the unlicensed jurisdiction relates to the lawyer's home state practice. And the best example of that is when the lawyer goes out of state to take a deposition, for example. Under those circumstances, he's not licensed in, say, Mississippi if the lawyer goes there from Louisiana, but that deposition in Mississippi reasonably relates to the lawyer's home state practice, and it's going to be okay. And then finally, permanent multi-jurisdictional practice. That is when you go practice in another jurisdiction, but you never become admitted there, is okay if you're an in-house or a government non-litigating lawyer, or if it's authorized by federal law. Like, for example, you are a federal prosecutor or something along those lines. Okay, that's a brief overview of the bar admissions process, the disciplinary system, and the consequences of a lawyer practicing in a jurisdiction in which he or she has not been admitted or after her disbarment. Now, having covered those, we'll move along to our next topic.